back in order. Yeah. So we're not there.
We're back live also.
Yes, sir.
245. This is
Birch and Thompson.
Birch.
Chatterjee.
We've got a quorum and it's 25 minutes.
Text everybody or let them know.
Here's Thompson.
There's Herbst, there's Thompson.
Yeah, can we go ahead and go forward?
And then let's get going because we only have about an hour and 45 minutes. So by the time this is over, we're pretty much.
Yeah.
What we're gonna do next. So
If we stop at,
You know what we're gonna do next, we're gonna have another meeting.
2:45.
if we stop then, how much time will we have between then and the, tour?
15 minutes.
So,
It's pretty much. The tour starts at when, and then we're gonna have to decide if we're gonna recess 2 times or to finish business on an online.
So I'm just gonna let everyone know really quickly before we get going. I will be moving to adjourn to a virtual meeting,
Recess.
a recess to at the call of the chair. So if, when we get to that point, probably after these motions, we're not gonna have time for much else. So if the chair wants to start thinking about a time that's amenable, or if we want to just like workshop this now really quickly before we get back in session, like what's a good, do we want to do it this week? Do we want to do it next week? Sooner the better.
You guys want to do it in June on the first Sunday? Because technically, for a policy manual, we can't have another meeting in 30 days.
Well, this would be the same meeting.
Right, so I mean, the next meeting. So we have the June.
Oh, I see.
recess meeting in there, and then the May 30 days out.
And I would have a point of order.
Point of order.
And I know we've done this before. We're allowed to do wrong things and then figure it out later. I do not believe we can recess a in-person meeting to an electronic meeting at the call of the chair. They are 2 different types of meetings. An in-person meeting is defined by our bylaws as a regular meeting. Our policy manual defines an electronic meeting as a special meeting. There are 2 different kinds of meetings. Now, the chair, we can adjourn this meeting, and the chair can call a special meeting to deal just with the remaining items. But it can't be a continuation of a regular meeting in which new business can be brought up. It's an entirely different kind of meeting. So I don't think it's permitted.
Well, I mean, we've done it before. I'm just gonna do it and let the chips fall where they may. I'm just letting everyone know my intention. We've done it. We did it for Miami. We didn't have to for Providence. Those are 2 hour, glorious times. 2.5 hour meeting, 3.5 hours.
And I'm just,
My rule would be in order, but I think the policy manual extension would be that if we were to create a meeting, if that's an online meeting, it would have to be a special meeting. So it couldn't be like an LNC board meeting like this. Because they don't need.
But then that would not, because I know one of the concerns is, we'll get it on the table, is certain members were not present. I do not think their absence can be cured by attending a special meeting that was not a regular meeting.
So that would be the separate meeting.
Well, that's all part of my point of order. There are 2 different types of meetings. And missing 2 regular meetings in the bylaws is, now the appointing body is free to absolutely reappoint the absent member. They can do that immediately. But if we adjourn, it's to a special meeting. It's no longer a regular meeting, so that does not cure that bylaw issue.
My rule would be if they show up and they vote, they would attend that meeting.
It's not a quorum issue, it's a bylaws attendance. So the bylaws say that any LNC member that misses 2 regular meetings, regular is defined as in person, that they will have considered to automatically have vacated their seat, and that the appointing body is free to reappoint them. If we adjourn to a special meeting, we certainly can take care of the rest of the business, but that is a special meeting and does not cure the absence at the regular meeting.
My rule would be that if that person or person shows up, they would, because they would have attended it, because of the circumstances of this recess, to an online meeting and they've attended that meeting. Under normal circumstances, we don't do that. We don't do that in 2 days. But I think the crux of the issue is special meetings versus a continuation of this meeting. I think only in-person meetings can be called in person, but they can be extended online or recessed to whenever. But if we were to create, we we couldn't create a meeting like this, we had to create a special meeting. So I think the genesis of the meeting dictates the type of meeting it is. I think it would be.
Well, yeah, so we can marinate on that when the time comes. We have the
I
power
mean,
to.
if we're
The board is welcome to overturn that ruling.
I
We
mean,
have-
if we're doing it now, I'm going to appeal the ruling of the chair, and I'm not doing it to be malicious, it is a sincere belief, and I have to. Point of order, I don't think that he's actually made that. Oh, yeah, that's what I'm trying to.
So I'm
clarify.
saying that like
So when
when
the
we,
time comes.
Okay.
when the time comes, I'm gonna do that, but I mean, we do have the authority
Okay.
to like do a standing rule, a special rule of order, and do stuff by teleconference, which would be like Zoom. So we've done it before. It shouldn't be a big deal. We should be able to get through these PM motions and then like at least be able to all agree to be on a call and do what we've done in the past. But when we get there, we'll get there. But right now,
Would it help if the business, the agenda was transferred to a separate meeting? So we committed to a separate meeting rather than just recessing or, continuing this meeting. We committed to a separate meeting, table all that business until then. Or postpone it rather.
When we get to it, we can discuss all that. All right, Paul.
Yes. I can let you know the names if you wish.
Okay, I don't know where Mr. Shatterton is. I'm assuming he's on his way back. Okay, well,
He's aware,
okay. All right, so
Well, we could try to grab lunch and then come back.
we're not gonna, if we get lunch, then we're not gonna.
all right. So I second Mr. Thompson's, and I thank him for his willingness.
So we are on to common sense motion number 6.
We are. Thank you, Mr. Chair. So this one again should be easy. Any current or former LNC, so this would be under conflicts of interest, section 1.07, obligations among board members and staff. Subsection 2, conflicts of interest. This would be added after the last paragraph right now. So this would just be new language. That language should read, any current or former LNC member, as well as the conflicted party in question, found to be in violation of this subsection, that subsection, of course, being conflicts of interest, shall be denied any trade relationship with the LP. This shall be separate from any additional action under consideration or taken by the LNC due to discovered malfeasance of personal financial enrichment. So as conflicts of interest reads right now, if I may speak to my motion, Mr. Chair.
I'll second it.
So just to briefly speak to this motion, so we already have something in conflicts of interest where should someone be in debt to the LNC, we already have something somewhere else in the policy manual where it's under, I forget where it is, but anyway, it's a debt of wiping of debt or whatever. So anyone that does business with the LP where they don't pay, the money that they're owed to us, or they wrong us in some way, they're prohibited from doing. We can go ahead and waive that debt, but they're prohibited from doing any sort of business with the LP, and it's because they've harmed us financially. So it just makes sense to add this under conflicts of interest. So should there be a conflict of interest, and should someone not disclose that conflict of interest, then they should be denied any trade relationship with the LP. So should the party that was contracted for this particular endeavor or whatever. So it seems to me a common sense motion. So yeah, that's all I have to say.
This one was.
My concern, and I'm in support of this, but my concern is we're a 50-year-old party. Is there any possibility of someone coming and saying 45 years ago, somebody did something that would have violated this? Does this prohibit them from having any kind of, and this isn't a hypothetical situation, I'm not going to mention names, but it's actually a real situation.
Right. So if I may, Mr. Chair. So I thought about that, and when I wrote this out, so I put found to be in violation of the subsection. So the only body that can find this to be a violation is the LNC. So if we decide that, I don't know if you said it wasn't a hypothetical situation, but let's assume that it is for the sake of this argument. 45 years ago, someone wronged us, and we are presented with evidence to show that we shouldn't do business with this person again because of whatever happened. This board decides if they violated this clause, and then we proceed accordingly. So it's not something that's automatic. That current LNC would decide if a conflict of interest situation arose where they should be denied any trade relationship with the LP. There could be a situation in which maybe that was the case then, and it's not the case now. They've had a come to Jesus moment, whatever it might be, whatever, we trust them now, everything is fine, but that would be up to the LNC to decide.
Mr. Malagon's answer satisfied my question. When we're done with this motion, I would ask to be recognized to move to amend the agenda. And I encourage voting for this.
Is there any further discussion?
Yeah, I may. I really do appreciate the intent of this. I've implemented similar policies in my own affiliate, so I really appreciate where it's coming from. My issue with it would kind of be that it would rely on selective enforcement from the get-go, and that's not. That means we already have evidence that it's not good policy from a policy standpoint. It's something that will immediately need to use selective enforcement in order to keep working, right? So that's my first criticism. If there's any way to maybe weaken that slightly, I wouldn't want to change it much, but if there's any way to weaken that slightly, that would be great. And then the other thing that would definitely get my vote is if we maybe thought about adding a thing that says we shouldn't have anybody giving the board legal advice unless they are a lawyer on retainer from the LNC. Like,
I mean, if we're gonna get into that, I'm sorry, I'm gonna pick on somebody who doesn't mind to hold it down. If Mr. Nicola was gonna give advice on a lunch menu because he's a food proprietor, are we not gonna allow that too? Why are we picking on him?
Are we gonna call Wendy's food?
I like Wendy's, okay? Show some respect for the Wendy's.
You don't take off the board for that.
Yeah, right? Like, it was okay before, but now, man, I don't know. Like, okay, but to your question, what I would, if I understand, sorry, that was wonderfully distracting.
My motion, the next LNC must be provided by Wendy. Is that a conflict?
It might be a
Only if it's in Miami, you're in Key West.
It's like this, if we're going to take into the official record serious advice from lawyers that have a legal opinion on something, right? They should be on retainer and have a contract with us. We should have that attorney-client relationship. It is, look, let's be realistic.
I was distributing to them.
Yeah, that's
Confused.
right.
I was suggesting we add it.
Why would, I don't understand
It
how.
seems
this
like
is-
a really good policy.
I think so.
Hold on.
An amendment can be
You
made.
can make your point, you have to be made the motion, if you wanna make an amendment or something like that.
Mr. Chair, if you don't think that part is germane, I would like to amend the current motion. Let's look at the shall, and let's say should.
Oh, God. I didn't hear a second, but
No, seriously,
I'd like to be recognized. if
we
there is a
should
second.
not do this, but if we're gonna start with selective enforcement, we can't have a shall.
Before you debate the reasons to your amendment, is there a second?
5 hours.
Mr. Chair.
Yeah, I wanted to comment on this regarding the point raised about, permanent denial of trade relationship, and what I understood to be the response was that would be at the discretion of the LNC. Again, as we've had several times throughout the business this meeting, the explanations that are provided to justify against these concerns is not reflected in this language. This does not say that the LNC can override that, and if such action were taken, it would be found to be it would be grounded that was a violation of the policy manual. So these responses that are given are very specifically, in my opinion, catering to implementing a selective enforcement on this, where basically there's nothing here that provides any exception to that. So if this statement in this policy proposal says that shall be denied, a permanent requirement must be denied. And I'm getting very frustrated with having explanations given that aren't reflected in the text order. substantiated.
Mr. Thompson, this one.
You know, if anything, I think shall should be stricken and replaced with shall in all caps.
I'm open to that amendment.
As a friendly amendment.
As a friendly amendment, yeah.
Of course. I don't really share the concern here, like, I don't think it's selectively enforced, I think it's it's up to the LNC to make a finding, right? It's not that someone has been found violated and then the LNC says, okay, now we're gonna trigger this. It's just, it would go before the LNC if someone is accused of such a violation. I don't think that's the type of problem being argued against.
Ms. Harlow, Mr. Ross.
Yeah, I was gonna mention a little bit of what Mr. Thompson said, but I'd like to expand. What?
About all caps.
No, no. Mr. Malagon addressed my concern, and the 45 years was hypothetical, but the situation wasn't hypothetical. So he addressed my concern in saying that the LNC would actually have to make a finding that there was a violation, and I think that's a protection. I do appreciate Mr. Chatterton's concern about selective enforcement, and the way to overcome that is remember, God, I hate the living document argument because like of the Constitution, but if the LNC really felt it imperative that this was a good relationship, the statute of limitations has expired on whatever this person may have done however many years ago, they can add a proviso to this. They can add an exception to this by a 2/3 vote. And if a 2/3 vote of the LNC feels we should have this trade relationship, they can always allow it. And here's the fact. I understand there's factions on the party, believe me, and I wish there wasn't. I hope I've expressed that to everyone. But if you don't got the 2/3 vote, you're not gonna have to vote for a lot of things anyway. That's just the political reality. Right now, we need to regain members' trust. Something really bad allegedly happened, and I am in favor of this to regain members' trust. I respect the concerns about selective enforcement.
Mr. Ross. Mr. Martin.
The one section that I was questioning initially is as well as the conflicted party question. I know the answer is going to be it's supposed to be you, but I don't know that it necessarily is automatically on them. So I would think about that part. But I do have a question. Would shall be subject to any different than shall be? Is this subject to engender a second step?
I think it's the same, subject to, and then clause. It's just a interpret subject to.
Right.
If we're missing the LNC review portion, does that supply it?
What's this found to be? I'm sorry.
Found to, who found, was it adjudicated?
I find it implied. I see.
I would move, I understand, I'm not trying to hurt this thing. Upon finding by the LNC. Or upon review and finding by the
You gotta give me
LNC.
exact language, Mr. Martin, because I can't read your mind.
Upon review and finding by the LNC.
Yeah, that's not telling me where you want it and what you want.
At the very beginning, before any current or former, it says of former, but it needs to be or former. If we could put before any.
Mr. Malagon, was that correct that should be or?
That's what's in the, yeah, any current or former member,
Okay.
yeah.
And-
All right.
Thank you. And upon review and finding of the LNC. And could you please insert the word proper between upon and review?
Upon proper.
And finding issued by the LNC is probably a good way to say that, yeah.
So much, dude.
Well, do we even have a second for this?
We don't know what it is.
Upon proper review and finding of the LNC, any current or former member, as well as the conflicted party in question, found to be in violation of this subject shall be denied trade relationship with the LP.
So is what I have there what you said?
Very close. Upon proper review and finding, maybe insert the word issued between finding and of. And then say,
Issued
instead of, yeah, say by. Upon proper review and finding issued by the LNC, any current or former LNC member, as well as the conflicted party in question, found to be in violation of this subsection, shall be denied any trade relationship with the LP. I would also, just before I finish my remarks here, I would just say,
Before you make remarks, you're making a motion to amend.
yes, you're correct, sorry.
Is there a second?
I'll second.
Thank
All
you.
right, speak to it.
The danger on this is the next clause, as well as the conflicted party in question, but I understand why it's there. And it should probably stay there and leave it on the review and finding issue by the LNC. With this, I would support this clause.
Is there any discussion? Mr. Cheddar?
I think that by including the reference to the conflicted party in question is assuming involvement there, and the policy above only describes improper action of the LNC member in having that conflict. So I think we are jumping to a conclusion to assume that the conflicted party was involved. Maybe I would propose a further amendment to say that as well as the conflicted party in question, if found to be participating in the violation.
I would accept
Or
that
maybe just
amendment.
say no.
So hold on. You want to make?
If applicable to finding.
There's a point of order that's, it's not even that it's not germane. Okay, I'm sorry, because I know this drives Mr. Malagon crazy, which I love to do. You can't amend things separated by multiple words like that.
I don't mean to, I mean to attach that if the conflicted party is to be included in
Okay,
the
so tell me
bar.
what it is
I
that you
think
want
it'd be
to
very
do.
helpful.
If I may,
Hold on, wait. If Mr. Cheddar, where would you want to put that language in?
So, on finding, interview, I like what,
After the comma,
so conflicted, as well as the conflicted party in question, if applicable, per the finding.
Oh my God, I have no idea what you're trying to
So
tell me.
I think you say comma,
There is a comma.
no comma, okay. so
if also found to be involved.
Do we put the word should in there somewhere?
All caps.
Only, I'll let the secretary decide where should go.
You can put in parentheses.
Only Mr. Chatterton does talk to the secretary, in the language that he's proposing to involve.
yes, sir.
Sorry.
Did you hear me? Did you hear what I just said?
No, I like what you were suggesting. So the consideration would read in total, upon proper review and finding issued by the LNC, any current or former LNC member, as well as the conflicted party in question, my amendment would be to add there, if applicable, under the finding. Which is like, that they
Yeah.
were involved
Yeah.
in the.
That is out of, I will raise a
Hold on.
point of order. I'll raise a point of order to the Steve. To the Steve. He's now the Steve.
Is
L Steve-O.
that clear at least, that the form is maybe not correct?
Okay, really slowly, okay, I think it, go, just very, very slowly so you can type it.
I raised a point of order before I typed it. You can't, I'm sorry, but Roberts is very complicated on amendments. You can't have amendments that are separated by words like that. I could tell Mr. Chatterton how to properly do it, and this would take freaking forever. I would suggest we pass this if everyone likes it, and then he makes his amendment. That's the easiest way to do it.
Okay. All right, so we're still on the Martin amendment.
Are we ready?
I don't like this amendment. What does proper mean? I think that the verbiage as it was is fine. I intend to vote this down and I call the question.
Is there a second?
Second.
All in favor of calling the question, raise your hand. All opposed? All right, we'll now move on to a vote. All in favor of the amendment, raise your hand. 3, 4, 5, 6. All opposed? 1, 2, 3, 4, 5, 6. So the amendment fails. All right, we're now back onto the main motion. Is there anyone seeking to recognize Mr. Chatter?
In case that of failing, I would move to strike as well as the conflicted party question.
Say motion to second to strike. We can remove the-
I'm listening to it.
Okay, I'm gonna be reposting this right here, so this did not pass, so we're back to here, and whoops, don't want a highlight, let me remove that highlight, please. So you are looking to strike this part here.
That's correct.
Go ahead. Like speak to your motion.
So since we have stricken down the consideration of qualifying that upon that finding, I think the policy manual position that this is describing a violation of has no statement about the party involved, and I think it is a false jump to a conclusion to say that a failure to disclose conflicts has necessarily to do with the party being engaged with. They are not responsible for the communications and approval of a contract within the party. That is an action between the LNC member initiating such contract and this board or whatever other body would consider it to be approved. So we should not be inflicting a punishment on an entity that is not by definition involved in the misconduct that we are attempting to address in this. So I would like that to be solely tied to the individual who violated the violation and limited there. And if there are considerations that do implicate wrongdoing from the conflicted party, that can be a conflict that can be presented as why we shouldn't do business with that entity. I don't think we need to have a blanket statement that jumps to a conclusion automatically.
Mr. Malaga, and Ms. Harlows, then Mr. Thompson.
I think we know what this is intended to do and I call the question.
Is there a second?
Second.
All right, all in favor of calling the question, raise your hand. 1, 2, 3, 4, 5, 6, 7. All opposed? 1, 2, 3, 4. All right, we're going to go ahead and call the question over.
But that didn't pass.
It didn't pass. Oh. Wait.
It
2/3.
requires
Oh,
2/3.
2/3, you're right.
If you vote, then it would though. If you vote to call the question, it would. Wait, yeah, 8.
You
Six
can't
to four.
re-vote.
Oh, 6 to
It
4,
voted.
6 to 4.
I don't believe-
Is there any further comment?
I
Any
do,
further discussion?
yeah, he had called on.
Oh, no, yeah,
Mr. Thompson.
Thompson.
How was that?
Yeah. Okay,
Getting late.
pressure, Mr. Steve.
No, for me.
Oh,
Mr.
okay.
Gentile.
To address, Mr. Chatterton's concern, I think it's actually in here and found to be in violation. I think we are really lawyering this stuff up a bit too much. I think to say found in violation means there is some kind of process there. There has to be a finding. And also, I could be Pollyanna, but I believe that people who are obviously conflicted, they know they're obviously conflicted. I expect certain ethics in business, maybe, I'm Paul Lennon with Imagine, but I don't have a problem with this, though I do appreciate Mr. Chatterton's concerns. We need to pass this as it was proposed. Thank you.
Yeah, I agree with that, having it say found to be in violation. I think that is the concern. If Stephen sets up Tyranny Knox and we has solved, yeah. And, and investors money there, and I think it's reasonable to say that they would be involved in it, right? Like, given the nature of the conflict of interest. If it were that he had an LNC meeting in the way meetings, I don't think it would be reasonable for us to say we can never get say,
disagree.
I think say, well, yes, I think say found to be in violation, takes care of that.
Mr. Martin, then Mr. Chatter, then Mr. Boss.
Thank you, Mr. Chair. Let me just use another example, kind of follow up on my colleague's point, and maybe contrast. I have a contract with Young Americans for Liberty, as you know. And I have provided a disclosure of this on my onboarding. However, this is the first time I've brought it up in the meeting. I intend to renew that contract, rather. I'm not technically in it right now, but my issue would be like, when you say like, if a member is found to be in violation of this subsection, I mean, I know there's more in the subsection above, but like, technically that wasn't, brought out in front of the entire meeting prior to the start of the meeting, right? And I'd already provided it in writing. So at what point is that, like, do we have a distinguishment on when that legal burden is met? Like, what if members are informing the LNC and meeting that burden, but the LNC doesn't get it and then feels burned and is acting like jilted lovers? With that, from a PR standpoint, that would be a very dangerous situation, right? You could have a lot of infighting covering up good communication, causing real problems on the board that would allow for a policy like this to be weaponized. I like this and it needs to happen, but there needs to be clarity that due process has to occur fully before anything is done on it, in my opinion. And a finding is
Make sure which states
a low bar.
Make sure all discussion remains germane to the amendment.
The word binding is a pretty low bar, implying that there's some sort of process that, obviously, there's some sort of process.
Yeah, it has to be on the amendment, not the main motion.
I'm not,
You see what I'm saying? Because we're on the
Oh.
amendment still.
I'm sorry,
It has to be
on the amendment to cross out the, as well as conflicted parties in question. Fair enough. I'll constrain my comment to that. The conflicted parties in question, we don't know necessarily that they're working with the conflicted member. Yao would not be acting through me. They've not talked to me at all about this, and I wouldn't tell them. This is a different thing, a different obligation. My job is to do political consulting, right? It's just not really related to anything that we're doing, right? And so those two things don't really intersect. But at the same time, like, when we're working in the Liberty movement and we want our successful people who have the networks and the resources to bring to the table, and we want them at the table, we don't want a way to start edging those people and those important relationships with aligned organizations out because we have policy, strategy, or ideology disagreements, right? We want these things to be decided basically on a case-by-case basis. And the board already has the power to do all of this. So putting this policy in is kind of a show. And I realize we feel like we need to restore trust, but be careful of the PR overreaction the other way, where instead of restoring trust, we're overreacting in ways that the public wouldn't understand.
I guess I want to make sure we say things.
I yield.
So to address one of the responses given about the statement that's included found to be in violation, I would like to emphasize the following text of this subsection. This subsection provides no provisions at which the contracted party could be guilty of any violation because there is no requirement on that outside entity. The requirement in this subsection is that an LNC member must disclose a potential conflict of interest before engaging in business. There's no obligation for the other side to be part of that. And therefore, there's nothing that a conflicted party could be in violation of. The only violation that could occur is of the LNC member in question. And so that is why I think it is improper to highlight I think it is proper to strike as well as the party in question because there is no violation here that they could be violation of. To give an example of that, let's say that a member of this board tried to initiate a contract with a valuable organization that we wanted to, work with, voter gravity perhaps, and say that there was an undisclosed conflict there. That, well, I'm using voter gravity because I think it's universally considered as a valuable asset to the party.
Some other things.
And that if a member of this board didn't disclose that they had a conflict prior, would that mean that proprietor was guilty of something and that we would bar ourselves from using that service in the future over the misconduct of an individual on the board. Mr. Ross.
Yes, I agree with that. The contractors or whoever outside this organization are not subject to the conflict of interest disclosure. It's us to disclose. And as far as found to be, not to be the grammar Nazi, the conflicted party in question seems to be tied to the LNC member. So if you find one, you find both. In my reading that sense, I don't think found cures that.
Mr. Malaga?
I.
Oh, okay, Mr. Malaga?
I mean, again, this is,
Yeah.
English is my second language, but it seems very, very clear. I will just read this again, and I'm against this amendment. Any current or former LNC member, as well as the conflicted party in question, found to be in violation of this subsection shall be denied any trade relationship with the LP. The LNC decides what they believe we can cross this bridge when we get to it, or if we get to it. The LNC can decide what is considered to be fair and equitable to the party, as is in the first paragraph of conflicts of interest. If something was done, if something was done incorrectly, it doesn't mean, as was stated before, I forgot by who, I think it might have been Mr. Thompson. If the Wendy's situation, are we never to eat at Wendy's ever again? I mean, I wouldn't because I like good food, but nevertheless, I think, sorry, Senior Chair. No, but I mean, the reality here is that that's already taken care of. Any amendments to this completely destroy, again, the intent and the purpose of this language, and it can't be amended, or else it loses everything.
Yeah, I think he was first.
Okay, so I'll let Mark.
I think, weren't you guys first? I think they were first.
Then I'm gonna be adjourned.
Please, call the question.
Yes, I'm gonna call the question.
Thank God. Second.
Thank you. All in favor of calling the question, raise your hand.
Of calling the question, right?
Of calling the question. Not only the question, this is just calling the question. 1, 2, 3, 4, 5, 6, 7. All opposed, raise your hand. 1, 2, 3, 4, 5. Question. Oh, I'm sorry. Yes, so.
These will continue till morale increases.
Thompson.
Well, as a means to come to some,
I'm sorry.
as a means to come to some unity on this, I do not think that this strike invalidates the whole thing, for one, and I forgot what I was going to say because I forgot to. Give me 10 seconds.
I have a point of parliamentary inquiry. How many times may a member speak to the same motion?
Twice.
So it seems that we've crossed that threshold multiple times.
Well,
I've been called.
Amendments are separate. You can
Who's
speak
the
twice to each.
No, that's what I mean. That's what I
Okay,
mean.
thank
Yeah,
you.
I believe that's been met by a few times over now.
Well, I'm just say this would get more people to agree on this. I think if this is stricken and it does not change anything. I still forgot what I was going to say, but I'll pass.
Thompson, you already spoke on one. Okay,
Oh, wait, have we voted on those on the one?
No, we're still on
This is the amendment.
Okay. I have another. After this.
Okay, and then. You've already spoken twice, so I'm gonna let Messina Scavin speak.
There are a number of different types of conflicting interest relationships, and there's no way that they could all possibly be fit into here. I think it's a common sense thing by the LNC at that time, whether the conflicting party was involved or not. That's part of the determination. Found to me means, there's been a process. There's been a finding. And the finding is either that the LNC member did this, or the LNC member and the conflicting party. I mean, the LNC makes that decision. I think it's clear, and I do think that we should keep it in, because otherwise we're kind of missing half of this here. If there is a situation when there are, for example, I don't know, yeah.
I'd like to
Okay.
check.
Mother and son, okay, for example. So, you know, I mean, or, I'm really disappointed in all of you because we missed nobody commented on the word paramour in the last.
I almost did. That is an excellent term.
Isn't that a great word? It's a great word.
Love that term. Nobody commented on it. There's a paramour relationship. There's, domestic partners. There's all sorts of things. So, which is why the
Throuple in there, I was really disappointed about
About a
that.
member-owned entity.
A member of a throuple.
throuple. Yeah, well, we could go back and amend. That's all I have to say.
Seems like discussion has ended. Ms. Cowan?
Oh,
We're still on the amendment.
I was about to say, we're still on the amendment.
I think that would be
All right, well,
appropriate to.
is there anyone else seeking to be recognized that hasn't already spoken?
I think that would be appropriate. I'll move.
Okay, in that case, I think we're gonna go ahead and move on to vote on the amendment.
I'll move it.
You all, okay, I wasn't sure if there was something.
I think there's an amendment that would address my concerns about this.
Can we just do this?
I think it would be appropriate for that.
We bring Jesus on.
If you go ahead and
Lord,
vote
that's
like
right
right
now.
now, and then she makes the thing, then we'll do what you want, and people will hate you.
Okay.
I have a question. Will the chair use his discretionary fund to buy me a bottle of alcohol for the remainder of this meeting?
I already asked for that. I have priority.
But now
I
I'm
caught-
asking.
I
Now
caught
it's,
shotgun, Mr.
You
Melvin.
can buy a lot of bottles for $5,000, just saying.
I would request a shot glass. Okay.
I don't need a shot glass, just the bottle is fine.
Trade that bottle.
I
So
said a
we're
bottle.
gonna go ahead and move on to a vote on the amendment. All in favor of the amendment, please raise your hand. 1, 2, 3, 4. All opposed, raise your hand. 1, 2, 3, 4, 5, 6, 7. All right, that fails. Ms. Coward, I believe you had your hand raised.
All right. So I was trying to address some of the concerns raised by Mr. Chatterton regarding the conflicting party of interest, and that there's really not anything in the paragraph above that kind of says what the conflicting party of interest may be doing in violation. So what I am moving is any current or former LNC member, comma,
1 second, I need to take off that. It's not taking off my strike out there. Okay, and now we need to make that blue again, and then we'll get to what you want to do. Okay.
as well as any, instead of the, so strike the and say any.
Correct, yeah, that could be more than one, yes.
Modifying next sentence.
What?
She's modifying next sentence, not replacing.
Okay, you need to be more clear. I'm sorry.
I'm sorry. So what we're saying is any current or former LNC member, as well as strike the, replace any.
Okay. It's gonna take me a moment.
Sure.
Uh-huh.
Okay, strike in question.
So it'll be any is we're adding that.
Uh-huh.
Okay, let me just highlight that. And you want to strike in question. Uh-huh.
Okay, and now we're good at found to be. And what we want to say here is, we're going to add this, and then we'll probably need to strike through afterwards. Found to be, and then add acting in concert with said member to prevent appropriate disclosure.
Violations.
Yeah, we're gonna strike the violation after, I'm sorry, yeah. Yeah,
Okay.
you're right on.
I think just procedurally, and I'll direct this to the chair, I think this is a substitute motion. This is
It's,
words that are all separated and all over the part. I think this is a substitute.
I think I remember Ms. Howard saying that.
Okay. Okay, so acting in concert with said member to
prevent appropriate disclosure. I guess we could say, yeah, pursuant to the subsection above. Yeah, and then we just need to wordsmith.
You wanted to strike this next one, right?
Okay, so let me just read through it to make sure, since we're kind of all over. So any current or former LNC member, as well as any conflicted party found to be acting in concert with said member to prevent appropriate disclosures pursuant to the subsection above, shall be denied any trade relationship with the LP. This shall be separate from any additional action under consideration or taken by the LNC due to discovered malfeasance for personal financial enrichment.
Yes.
Okay. So in the subsection above, what was here, what this is talking about is just the LNC member. Which makes sense because we can't have policy, for hypothetical situations for any, hypothetical conflicted parties of interest. What this does is say that the conflicted party of interest only becomes culpable, if you will, if they're found to have been acting in concert with the former current member who is doing the naughty things.
Ms. Howard, perhaps you can speak to your motion.
Oh, sorry.
Second.
Second, yeah.
Seconded.
Okay.
What you just did.
I'm sorry, but I did it directly to Kathy. So what the concern that was raised was that in the subsection above, it's talking specifically about the disclosures the LNC member needs to have. So it's talking about the current or former LNC member in terms of what the expectations are there. What I was just saying to Ms. Savage is that when it comes to the actual conflicted party of interest, we don't have a policy regarding any expectations there because it's hypothetical conflicted party of interest. It's a hypothetical situation. What this does is specifically says that the conflicted party of interest is only culpable, if you will, if they are found to have been acting with said current or former member to prevent the appropriate disclosures. Which I think was implied before, but this just says it
Mr. Mallon,
more explicitly.
I think I understand what she's trying to do. I'm not sure I like it. If this does
It's
fail,
wordy.
the only thing that the one part I do unequivocally like is the change strike. So I will, if this fails, I will make an amendment to strike the and switch it with any. I do like that. That's a really good one. The rest, I'm not sold on, but that's just me.
Yeah, I remember what I was gonna say earlier, and it's applicable. So we're amending the policy manual, which takes a certain threshold, whatever. I think and we're talking about fixing it later if it's not right. So while we're here, we keep it limited and get it right as we can. And I think this does that.
Discussion going once, discussion going twice, 3 times. We'll move on to a vote. And with that, so we could do show of hands. This would substitute the main motion. Which would become this. Okay. All right. So all in favor of the substitute motion, raise your hand. 2, 3, 4, 5, 1, 2, 3, 4, 5, 6, 7, 8, 9. All opposed, raise your hand. All right, motion passes. So we're now on the new main motion, which is what we just adopted. Is there any discussion on this? Mr. Bernat?
I call the question.
Second. Call the question in a second. All right, show of hands to call the question. All opposed? All right, that's 2/3. We're gonna go ahead and move on to a vote. Roll call. Madam Secretary, whenever you're ready.
I want to just read out loud what it will say. Any or current former LNC member, as well as any conflicted party found to be acting in concert with said member to prevent appropriate disclosures pursuant to the subsection above shall be denied any trade relationship with the LP. This shall be separate from any additional action under consideration or taken by the LNC due to the discovered malfeasance of personal, financial, enrichment. Go now here, number 7. Mr. Boss,
Pass.
Mr. Chatterton,
Abstain.
Mr. Dar,
Yes.
Mr. Dassing,
Yes.
Mr. Ford.
Yes.
I will vote yes, Ms. Halsey.
Pass.
Mr. Hurd,
Yes.
Mr. Martin.
Yes.
I hear you.
Yes.
Mr. Malagon,
Pass.
Mr. McGee,
Aye.
Mr. Redpath,
Yes.
Mr. Thompson,
Yes.
Ms. Yanuskavich,
Yes.
Mr. Boss,
Abstain.
Ms. Halsey,
Yes.
Mr. Malagon,
Aye.
okay, Mr. Chair, is 1202,
Motion passes.
and I had asked to be recognized.
All opposed?
I'm trying to scroll down here, but I'm moving to amend the agenda to move up Mr. Malagon's motion that he had noticed later. It was of a group of 3, so I've labeled it motion 2-2. It is related also to conflicts of interest, so it was related to the last one, and it was to add this last sentence that's on the screen. And I'd like to consider this one now. And I'll speak to my motion if there's a second.
Wait, I'm sorry, what was?
She's moving to amend, move this one
Consider
now.
this one now.
What's this one? The one that's on the screen?
Yeah.
All right, there's a motion to consider the motion on the screen next.
Yeah.
There's a second. Charles, like to speak to your motion?
So the motion
Wait,
right
did
now.
we approve, it's to amend the agenda, right?
Right,
Right,
it's
yeah.
to amend the agenda, but I wanted to give a reason to, A, it's related, but B, there's very many members here who, A, I think the word consulting is very vague, but depending upon how we define it, there are members who are currently in the middle of this right now. If this passes, they need time to wrap it up. I will speak to myself personally. I'm under contract with the Libertarian Party of Florida. If the LNC passes this, they are passing and approving a breach of contract. So I will say, if we do move to consider this now, the first thing I will do is move a proviso for a later effective date to give everyone on the LNC time to wrap up any obligations that they have so that we're not causing any kind of breach of contract.
Was this seconded?
Yes.
It was. Mr. Redpath.
Inquiry, whatever. What is the purpose behind this, Madam Secretary? You're moving this, why are we considering?
Why are we considering the amendment?
What's on the screen? Look.
I didn't make the motion.
Okay.
She's moving to,
She just wishes.
I want to consider it now.
I'm sorry, okay, all right. Okay.
It's in the same section.
It's in the same section and there's upcoming contracts that will be in violation if this passes.
Section. New business of previous notice, so it's actually a different section.
No, but it's
Oh, I
conflicts
see
of
what you're
interest. It's
She's
under
moving it up
conflicts of
because it's
interest.
under this, is what I was intentionally moving for. I mean, I had two questions before I mean, we're gonna get to this at some point, or maybe not. So I guess what is the concern here would be my first question. And then I was actually going to, before I actually moved this, I was going to amend it before it was actually seconded. And it was going to include, because when I wrote it, it occurred to me that it could theoretically have implications. I don't think it did, but just to remove all doubt, it could have implications for Mr. McGee, for instance. He's the executive director of Alabama. And I don't believe it's a paid position, but still to have it. So I was going to actually say, I was going to amend it to say at the end, unless the member is also a resident and member of that state, in which case it would just be to prevent LNC members from providing consulting services where there might be a potential conflict of interest with other states. So my question, I guess, is what contracts could potentially be broken here before I guess.
Sure, I'll let you.
Yeah.
know. The Libertarian Party of Florida contracted with me to be their convention parliamentarian, which I actually don't consider a consulting service, but in 2 weeks. And they've been relying upon that for 2 weeks. So the first thing I would do is to move a proviso that this would go into effect in 3 weeks or something like that. And I can tell you my personal intent is not to provide any services to any other state after that time. But for the LNC to move for even one of its own members to have a breach of contract situation, I think is inappropriate. So I'd like the time to fulfill that contract, and I would give my word to, I have no problem with it being enforced after that. And I like your amendment.
We're getting a little bit of discussion on the actual motion, so let's keep it to whether or not we move this forward for discussion. So, Mr. Martin.
Yeah, so I gotta share with you guys what I told my region. They're really tired of this kind of crap. And don't get me wrong, like this looks good on the surface.
Make sure, because I kind of allowed it, but I really should.
Mr. Chair, absolutely.
Whether or not we consider this now, or because we're not actually discussing the motion.
Oh, we're discussing whether or not.
Discussing whether we're discussing.
Whether or not.
Pardon me.
Whether or not we bump it up in the agenda.
Yeah. No, this is definitely, you know what, never mind, I yield my time.
Since we're already discussing, I prefer that we go ahead.
Okay.
Yeah.
Let's go ahead and go to a vote. Vote would be to consider this for discussion next on the agenda. All in favor, raise your hands. 1, 2, 3, 4, 5, 6, 7. All opposed? All right, we are now into this item. Mr. Maldo made the motion and would require a second.
So before anyone seconds, I want it with the amendment that I was going to add.
So it would not be with notice if you provide it with an amendment from the gate. I'm sorry, I just should have asked to be recognized, sir.
This is already without previous notice. So she
No,
moved.
it had previous notice.
Oh, I'm sorry. Did it?
Yes.
Okay. Yeah, I'm just kidding. I was testing you. You passed. A+. So I would amend this to before it's moved, just to prevent any sort of anything. It would be just add at the end.
Inquiry, Madam Secretary, can he amend it?
No,
before-
you need to ask the chair.
Mr. Chair, can you confer with the secretary to find out whether or not this can be amended prior to its introduction and still be considered new business with notice?
Yeah, I don't think there's any way around that. Now, yeah, I concur with Mr. Martin's point. It would have to be moved and seconded in order for it to be amended because it has already been moved.
Thank you, Mr.
Okay,
Chair.
I'll make the motion then.
All right, is there a second?
So I would like to, before I speak to my motion, I would like to amend the motion, and I would like it to read at the end. So after bylaws, instead of the period, comma, unless the member is also a resident and member of that state, period.
Is there a second?
Second.
All right, we're now in discussion of the amendment.
I will speak to them.
I'll let you. Yeah, the amendment.
I will speak to the motion by calling the question.
I think, motion, question,
Call for the question.
Mr. Maldo.
Yeah, but other people have their hand raised. If the amendment was made, I can't immediately then call.
He's calling the event.
I'm calling the question of the amendment, so we can just get to it as the main motion.
You move to amend.
You know what?
can't
Let's let's make that happen. We're all in agreement. We just want to talk about it, right? We don't have to drag it out. I'll yield my point. Thank you, Mr. Chairman. You're right. I'll just waive my objection. There's no other objection.
Okay, so we're gonna call the question, is that?
No.
Just on the amendment, yeah, just on the amendment.
So, so I called the question on the amendment, not all previous questions, so we can't actually discuss the main motion, which is now.
All right,
You know,
all in
once
favor
we
of
vote on this.
the question on the amendment, raise your hand. All opposed, raise your hand. All right, we're gonna go ahead and vote on the amendment. So if you're in favor of the amendment, raise your hand. All opposed? All right, amendment passes. We're now on to the main motion. Wait, what's going on? Oh, wait, that was just on the, yeah, not on the amendment, right?
Amendment passed.
The amendment passed, so now this is the main motion, what's the whole thing, but it's still highlighted, but she's working. 'Cause
Yeah, I know.
She's typing with one hand.
Yeah, I'm doing it.
So
with
I'll
one.
speak to the motion while
I'm
this
so
is going on.
confused. Wait, I just confused myself. Wait.
The amendment passed, we're now on the main motion, Mr. Chair.
Oh, this is all, okay, all right, gotcha. That was a lot of hands. I was like, reloading. I was like, okay, so,
Passed unanimously, look at that.
all right, so let's do it this way. I'll just go around the room and else. So we're gonna do,
Well, may I speak to the motion?
yes, go ahead. Steve.
Okay. So we kind of already got into it a little bit. That's fine. I mean, it seems that the secretary's in favor of this, which is good. I just, while we're doing conflict, I mean, she made this point early on, and I think it's very poignant that you could really go through the policy manual. I just kind of went through the most pressing things as I saw them and tried to submit as many changes as I could that would be beneficial to the LNC and kind of put us in a place where we are now gaining the trust of the membership again. She makes an interesting point about Florida, and there is already a contract. The chair of Florida is here, Mr. Johnson. Ironically, it defeats the purpose to wait until after the conflict has passed. But I mean, if there's a contract already, there's an understanding. I don't wish to hold that up or do that. I don't care about a proviso. If we want to do that, that's fine. I think it's just really important that we do set boundaries and a line between the LNC, your particular affiliate, whatever you do there, and then quote unquote meddling or providing services to any other affiliates that could be possibly beneficial to certain factions, certain members, etc. And I think we need a very clear distinction, a clear line between what LNC members do as their fiduciary duty, as their to the board versus to an affiliate or to a particular caucus or whatever. So that was the intention behind this motion. I yield the rest of my time.
I've got Marlo Starr, Daphne Thompson, Brett Padmore.
Okay, I would like to move a proviso that this does not go into effect until mid-June, and
Can we do a specific date? I'll second it if you have a date. for after the convention.
you guys aren't moving your convention, are you? So
June
June
6th through 8th.
15th, I'm just going to say, and the secretary agrees that if any conflict arises over the Florida convention, she will recuse herself from any vote.
I'll second that proviso.
All right, we have a motion and a second, so now we are on the proviso amendment. Questions? Yes.
We will give that the list of questions.
Sure. Yeah.
I think, just for parliamentary purposes, does that proviso disappear once it's been effective?
Yes.
Okay, that's all.
All right, Martin, do you have your hand up for the proviso? Are you thinking to be recognized for the discuss the proviso?
Yeah, look, I've promised to help. This violates my regional agreement, the proviso and the entire thing. Just so you know, if the regionals are supposed to actually do their job and show up, they will be providing services. State chairs who call each other, provide information to each other. This is ridiculous. Services? This angers me, Mr. Chair. I am upset by this. This is an attack on the region. Once again, a weaponized policy. I yield.
So my question is, I know certain regions give stipends to regional reps to go to meetings. Does that fall in a conflict?
No, this is,
Reimbursement.
it's a reimbursement.
No, that's a
Also-
contract.
So then also, yeah, because that's what I was asking. And then the other one is speaking at conventions. So some people on this board have been asked to speak at conventions. The state pays them to come. Does that count as well?
I
Are
don't,
you talking
But
fee or
it says
reimbursement?
compensated. So that's why I'm asking.
well,
Motion
so,
to table all remaining business and
Also-
adjourn for
so-
lunch.
I mean, Mr. Chair, and address Mr. Jackson's question. So that's not, if you're speaking, that's not a consulting service. You're not providing any service. You've been asked to speak.
Okay, I just wanted to
It's not a
clarify
problem.
that.
Ms. Harlow, just,
Okay, Mr. Martin, please, no, I'm not speaking down to you, because I know you're new on this body. I would urge you not to vote against the proviso, even if you ultimately vote against the entire thing. Because at least you will not be countenancing a violation of a contract with Florida.
Thank you.
So, I understand your objection to the whole thing, but the proviso at least protects a contract that's in place.
Understood. Would it be possible to add to the proviso that,
hold on, you don't recognize it yet. Yeah, I'll you next. Mr. Thompson?
I was wishing I was gonna speak for me.
Oh, okay. Okay, just one.
would it be possible to add to the proviso that, actually, I don't know if we can even do this. You can't change the regional agreements. You can't protect it. This is against the bylaws, so I have to object to the consideration of this motion.
I would call it in order. I don't think it's.
I would appeal the ruling of the chair. You're right, you're right. I withdraw my appeal. I apologize. I find this very troubling.
Is there any more discussion on the amendment to add the proviso? All right, hearing none. Is there any objection to the proviso? All right, hearing none, we've adopted the amendment. So we're now back on to the main motion. So I'm going to go down the order of hands that was before. I think, do I have Dassey? All right, so Thompson. Oh, yes, Dr.
So I wanted to also clarify with this, so sometimes states ask for advisement on IT matters. If it's not my own state, am I no longer, just so that I know, I'm not supposed to do that anymore? Should I not be advising on any IT matters to other states?
Yeah, I would say that falls into that you're consulting for a different state, and there could be, and it's not a slight on you. I'm sure, I mean, you're fine at what you do, but it's to prevent, I mean, this is just an overall kind of umbrella thing to prevent any sort of, for all we know, you can manipulate tech or help them with something to help them for a convention or do something, I'm not saying that you're doing that, but it's to prevent any sort of that kind of potential malfeasance. I'm trying to cover, when I went through the PM, it was to prevent all potential types of malfeasance and draw a clear distinct line between the LNC and other affiliates outside of your own. So of course you should be able to help Texas, but what if a different state wants your services for whatever reason? So that was the intention behind this. So that would prevent you from doing consulting services voluntarily, whether they're voluntary or otherwise for other states. Correct.
Understood. Thompson, Redpath, Mark, Johnson, Harlow, without objection. Mr. McMahon from the gallery, and then Mr. Ford. So, Mr. Brown.
Yeah, I would encourage everyone to vote this down, please. So in this regard, hypothetical, right? If he provided some IT consulting services to Louisiana, that is a benefit. It's not malfeasance. It's not harming the organization. We don't really have enough volunteers in the military party that have expertise in certain areas to wall them off to their states. Right? Like I have done consulting on voluntary basis for certain things of affiliates. It was not harmful to the party, it wasn't harmful to the state. I think it is a bad thing to do. I think it would prevent a lot of good work.
Mr. Redpath. I am even more lost than you right now. What's the problem that this is trying to address? Number one, I'd like to know that. Number two, what about ballot access? Does this mean that I can't work with various states? I talk ballot access with a number of states
not so much right now, but during election years, most definitely. I mean, would that be viewed as consulting? And I'm consulting with other states on ballot act, but what's the problem? What is the problem that this motion is trying to address?
General conflicts of interest. I mean, you're on the ballot access. Well, you're not now. I mean, you were and you would be again. It's a ballot access here. It's an LNC driven. Mr. Thompson makes a fair point. I just brought this. It's up to the board to decide. I was just going through and trying to figure out and trying to wall off any potential conflicts of interest where it could be seen that the LNC is meddling in other states for some sort of potential gain for a particular faction or for a particular end or purpose. So that was the only intention here. The LNC is welcome to vote it down. I just presented it. Mr. Thompson makes a fair point. You know, we are limited in certain things, but it doesn't mean that I would never accuse Mr. Dar of being, he's as a straight shooter as they come. But, you know, this doesn't mean that it can't happen or it's not happening now in certain elements or respects. So that's it. The LNC is welcome to vote for it. I think it's a good wall off from the LNC to everyone else, but it's up to you guys to decide. It's up to the body.
Hey guys, feds are real. Let me tell you something about this. This, Mr. Chairman, this would shut us down. This would violate our regional agreements and violate our bylaws. And in combination with some of the other crap that we've passed, which seems very well intended, if we pass this, we will cut off the ability to do business with vendors in general. This is bad. And let me tell you how I got here, guys. I went to my region with an idea. I told them, how about I come and back you up? How about I come and speak to your state legislatures on some basic bitch libertarian principles? And how about I come help you kill some bills and move the needle?
Is this germane to the motion?
Yes, yes, it is, because this is
I'm
part of
asking the chair, Mr. Chair.
You haven't heard it yet.
I was almost gonna actually say something. I know you're very passionate.
Pardon me, this is about a consulting service I am providing to 15 states, okay? Currently, this targets me. And let me tell you, I promise to go help them fight bad bills, redeem our name in the eyes of people by showing up where the real fight is, which isn't in this room, it's in our capitals. I'm showing up and bullying these stupid politicians who are way worse than all you guys. This is funny. You guys don't know what real evil is. If you think the evil is sitting at this table, you are mistaken. The reality here is this is an overreaction, and a really unfortunate and immature overreaction from somebody who is very intelligent, very capable, very talented, but unfortunately has misunderstood the situation. This will hurt. We can't do this. I will go and I will do this, whether you guys ban it or not, because I will fight the fight for liberty. I will fight these gun bills. I will fight the fight against free speech. I will go and show up in my states and do this, whether it's paid or not, because I gave my word and I will keep my contract and I will not accept the proviso that will tell me I can stop. I gave my word to 15 states that I will show up as a member of the LNC and help them. And they are applauding. You can hear it through the camera. You guys need to understand that they feel like you're making war on them, and we have to stop this behavior. You want to fix member trust? Stop attacking your most dedicated activists. Who do you think doesn't trust you? The general public? They don't care about you. It's us. And you're talking to one of the people whose trust you've broken. And how have I been treated in this meeting? I had a real suggestion. And I warned you that we would waste time on a dozen weaponized policy amendments, or we could have figured out how to get contractors that actually implement PDR, win elections in states, and do what I'm suggesting, go before the legislatures and fight for our people and their rights and show the American people that we stand for something, for God's sake.
I'm gonna stand right now. This is Jesus
Yeah,
Christ.
I will too. Sir, I object to this. This is something we should not consider, and we need to vote it down right now.
Thank you very much, Mr. Martin. Mr.
I don't know how I'm gonna follow that up.
Much love, I'm sorry. I get
Must be
into
the
it.
brevity there.
So Mr. Dar provided a hypothetical. I'm not going to provide a hypothetical. I'm going to provide an actual. I own a digital marketing company that does website design and digital marketing. I can't be the only one. I know I'm not. An amendment like this is telling me that if LP Fulton County in Georgia wants me to redo their website, I can't freaking do that. You're kneecapping my paycheck, and I don't like that.
Your state, no, so the.
That's at Fulton County, Georgia.
Oh,
So
sorry,
if Atlanta, Georgia wants me to redesign their website and implement Nation Builder because I've done that for Florida, that's a hypothetical, but you're kneecapping my
They
income.
would, correct, yes.
You're kneecapping my income, and that's not libertarian at all, in my opinion.
This is part of the conflict. But you get,
But-
that's the point, but you're not wrong.
Okay, I have a potential amendment because I mean, Mr. Martin, I appreciate your passion, but I also understand what Mr. Malagon is getting with. This in fact happened
For the
in
RPH 2.0
Michigan,
for my company. And of course,
when there was a dispute
conflict of
over
interest.
delegates and the LNC was going to vote to encumber $5,000. I was their convention parliamentarian. I recused myself from, I didn't even attend that executive session. So perhaps an acceptable amendment would be, I'm kind of working this out in my head, would be to add to the end, unless such services are timely disclosed with the, crap, I'm not wording this great probably, with the LNC having ample opportunity to disapprove. Yeah, unless such services are timely disclosed, might handle it, because I think it's already implied that if someone discloses a conflict of interest, that the LNC could then prohibit that member from doing that action. So just to give Florida as an example, I disclosed it back in January, which is when I was contracted. So if anyone was contracted with anything, the minute you disclose it, and then the LNC would have an opportunity to determine, is this really a risk? So this is my amendment. It's not worded the best.
I'll go in a second. Okay, so you had a second for something.
I have a point of inquiry. The secretary made she just said something, and I don't, like, where are we allowed to, so if someone releases a potential conflict of interest, where does it say that the LNC?
I think that's under our plenary control of the party.
Oh, but I'm sorry, my question, I guess, is, it's not something like in the policy manual
It's
that
not,
exists.
no,
You're
sir.
saying it's an implied,
Yeah, I think it's
an
implied.
implied action. I see. That's
So, Ronald Harlow's amendment, Mr. Foster, was that a second?
That was not a second.
Okay.
I'm waiting for the second to
Okay.
actually discuss it.
Is there a second?
Yes. Doesn't Robert say that you cannot force a recusal?
None of this says you can force it. As far as the Florida thing, I voluntarily,
Right,
Agreed.
it's with the example you gave of Michigan as well, which is voluntary, but.
it was voluntary.
But to Mr. Maligon's point, the consideration of, is it actually implied that the LLC can act to disallow participation in the event?
That wasn't my suggestion. I think the LNC can say, you providing those services are in conflict with your duties as a board member, and you need to choose. I mean, maybe I'm wrong. My sense is that's implied. Like, I'm just using you as an example because you started talking to me. Where you said, if you said, I'm going to go work for whoever was running against the libertarian candidate for governor.
Everybody stop. I'm trying to figure out what you're saying here. I understand in interest, I don't know. Fair to me. So we do have a motion that is being presented, and we need a second for go to discussion.
Second.
Okay, we have a second, Mr. Voss, then Mr. Thompson.
Your amendment to this, it sounds like we're just saying if you have a potential conflict of interest, disclose it, which you already have. That's my comment.
Well, that was going to be my question, actually. What does this do?
Go across stuff, yeah, let's let it finish, and then we'll go around the room, and I'll recognize Mr. Thompson.
Yes, so might as well just put the whole thing down.
Right.
So my preference on this is to vote in favor of Ms. Harlow's amendment, and then promptly and thoroughly vote the entire thing down. But also we have a hard stop, I think, about 15 minutes, so that we can please get on with it.
30 minutes.
2:45. 25 minutes.
I moved to
Oh, sorry.
Thank you. I mean, well, yeah, I mean, the amendment defeats the purpose of the thing. So again, I just brought it up, as I told Mr. Redpath, I was just telling Mr. Johnson, this wasn't an attack on anyone, it's up to the board. You know, you can make a decision as to what I was going through as much as I could for the policy manual. This was gonna be an uncomfortable one. It's fine. Some people are very passionate about it, others are not. It's whatever, you know, it's up to you guys to decide. I think that there should be a distinction, and that the LNC should decide that you're going to be on the LNC or you're going to provide these services or do whatever, because when we've seen what happens when worlds collide, it's not great. And it's not an attack on anybody specifically. It's just it was a general observation. And I thought that it would be good to bring forward. You guys can, if the amendment passes, there's no point for the entire, Mr. Boss had hit the nail on the head. Amendment passes, the rest of it doesn't matter. The whole thing is pointless. So it's really up to this board to decide. I did what I thought was my due diligence when I was going through and trying to make some of these corrections. If I'm still recognized, I'll call a question because we do have to get moving along, and people already have decided what they're going to do. All previous questions, that's what I meant. I was looking at my throat.
There's a motion and a second to call all previous questions. There's an objection, so we'll go ahead and vote. All in favor of calling all previous questions, raise your hand. 7, 8, 9. All opposed? All right, that's 2/3. We're going to go ahead and vote on the Carlos amendment first. All in favor of the Carlos amendment, please raise your hand. 6, 7, 8, 9, 10. All opposed? 2, 3. All right, amendment passes. So now we are back on the main policy manual amendment. As amended. Excuse me, as amended. So this is the main motion, which we will do through a roll call.
Corrections, 3.
Yours 3, I'll change it. Okay, so this is as the main moment, excuse me, the main motion as amended, Mr. Boss.
No.
Mr. Chatterton.
No.
Mr. Dar.
No.
Whoops. Mr. Dassin.
No.
Mr. Ford.
No.
I'm gonna pass. Ms. Housley. No. Mr. Hurd.
No.
Mr. Martin.
No.
Mr. Malagon. Mr. McGee. Mr. Redpath.
Point of order, I thought he couldn't vote against his own motion.
It was an amendment.
Because it's been
Yeah.
amended.
So because it defeats the purpose
Sorry,
now.
sorry. I will vote yes on this.
But also hilarious.
No, we're on the main
We're on the
motion
main motion.
Okay,
as amended.
As amended.
no.
Mr. Thompson.
It's very close, so I'm gonna say no.
Ms. Yaniscavich. I'm sorry?
No.
I pass, I'm going to abstain. Mr. Nikela, it is 0-13-1.
Motion fails. So according to the orders of the day, we are back on
The next.
Yesterday's
Malagon. Which would,
Common sense motion number 7.
There's 9 of them.
This one should be super easy.
don't say that. Don't say that.
He said jinxing the whole thing.
Is it time at this point to start another one, discuss how we're going to carry out the meeting? It's still a significant hangover.
So
Yeah, hangover. Sure. How are we going to handle, we need to get out of here about.
as soon as this is done, I'm going to move to adjourn
So it is.
or recess.
Out of here, Nathan? Well, I mean, we've got someone meeting us a couple minutes before 3. We have to get all our stuff out of here. Don't suggest it, our stuff here, because this will not be a part of the room. Okay? And, you know, people's got to, is it time to, however we're going to call the meeting, to do it now, or whatever mechanism we use to carry these forward.
Give me the hard time that we're gonna get out of this.
I would say about 2:32.
I I will move to recess at the call of the chair.
I move to address now, on the agenda, to discuss December LNC meeting by Mr. Maladon, scheduled for 10 minutes. I would think that would be something worth discussing at this point.
I'll do that. I'll withdraw. There was no second. There was no second. I didn't hear a second. I can do that. That's fine. It'll take less. It'll take like 3 minutes. So we can do that and then knock it out.
December, okay. Is there a second to?
I'll second.
Mr. Redpath's motion? Just did. Motion made, second. Any opposition? Yeah. All right, no opposition to that motion.
Okay, so really quickly, I've spoken with the chair about where the next LNC meeting will be. He has graciously allowed it to, he's going to do it for California in December. It's going to be in the Bay Area. I don't have the specifics yet. I will get those pretty soon to everybody. You'll have the benefit of the most successful time that the LNC had a fundraiser was California and Orange County. We had a turnout. Yesterday was a good turnout, actually, but we had a turnout down there about 80, 85. The LPCA at the time kind of didn't take any funds, gave everything to the LNC. All the fundraising that was done was there. It's also the backyard in the Bay Area is near the backyard of some of our biggest donors in the party. So it gives us an opportunity while we're talking about the budget, what we're going to do, planning for the future to accommodate that. So it was very gracious of him. So I just wanted to kind of give everyone an update on that. And as more details come out as far as what we do, like where it's going to be held specifically and all that stuff, that'll come out in due time.
Question. Is this meant to be the next in-person LNC meeting?
I believe it would be, yes, it would be December. The budget meeting is always in December, and it's I don't think there would be another in-person meeting between now and December.
Okay, and do you have specific dates?
So that was one of the things I was going to bring up. Sorry about that. So last time we did it traditionally, so obviously with Christmas and all of that being around that time, I would think that, I mean, we have to schedule it for whatever so it'd either be the first week in December, which would be the 6th and the 7th, or the second weekend of December, the 13th and the 14th. And that's really, I think the 20th and the 27th are off. So it has to be the first 2 weeks of December. I believe last time we did it the second week of December. I can figure out either, but depending on what the majority thinks that they can do, whether it's the 6th or the 7th, 13th, 14th, that's kind of the dates that we're looking at. So we'd have to obviously go with the majority, make sure that we have quorum for that, and I can start making appropriate arrangements and all that.
In California may very well be the best solution. I would suggest that, particularly given that there was conversation about the dates of the next convention, that we be open to number one, there's plenty of states that have never had LNC. And number two, that we look to, and maybe going to be an additional conversation we're going to have the 2020 presidential, that we consider that as a potential. I don't know that we're in any rush, right? That's something we easily do by email that. Again, California may just be very well the best choice, but I think there's plenty of areas that have never had that. And we've seen positive impact of having commission. So I'm just going to ask that we perhaps defer the conversation and put it out into the list.
Ms. Martin? I move that we postpone all business to the call of the chair and adjourn.
Is it adjourned or is it recessed?
Recess to the call.
Okay, recess is when you stay in the same location for a limited period.
Adjourn.
So it's adjourned at the call of the chair.
Recess is the correct language. As we're recessing. Oh, I'm sorry.
We're postponing all business to a future meeting at your call.
Robert's reference, that is not the.
We're postponing, not tabling, but postponing all business to a future meeting.
I don't think postpone is the correct modern term. I don't think that's.
I believe that is the only term that would transfer it to a new meeting.
No, recess.
It would be an adjourn at the call of the chair, which is something I would say I would do. Ms. Harlow disagrees with that now, but it is a special rule of order. We've done this in the past. It's not a big deal. We will take, and it will allow the LNC members without having to go through a vote and bring them back on and do whatever. We still have a lot to get through. It's not like we're adjourning early. Mr. Ford has, scheduled a tour. We didn't get through a lot of the stuff. We have to just do it now and just do it. So it is what it is. We're allowed to do business via teleconference. This seems like the best solution we've done in the past.
Recess is when the same meeting is continued. Postpone is when it goes into a different meeting. Postpone, we can put a different date on it and we can have a new meeting to address the same agenda. Recess means the same meeting gets continued.
At the same location.
At the same location, and that's important, right? So if we want to address this via Zoom, we cannot recess. We must adjourn.
So here's my ruling. Recess, and this is how I'm gonna rule on it. Of course, I can be overturned. But I'm gonna say recess would be the only option that's in order, because it's the only one that, it's basically an intermission in a meeting, where adjournment means we close the meeting entirely by moving to adjourn.
Or, so recess to call the chairs, but so that would be the motion.
Postponing is an.
So recess at the call of the chair,
Correct.
and the notice is.
So you can send us an email, so we have the call, so the motion would be to recess at the call of the chair. You would let us know when you're continuing the virtual meeting.
Would you guys be cool with Sunday, June 1st, which is when our next LNC meeting is anyway, at 7 p.m. And that gives us 30 days, so that in July, we can have our next meeting, so we close on Sunday. We allow us to get our next one 30 days out.
What time on June 1st?
7 p.m.
Eastern. So I'll move to recess for June 1st
Wait,
until June 1st.
Oh.
It wouldn't be at the same
At
location.
7.
No, online. Do it online.
Yes, I move to recess to an online meeting on June 1st at 7 p.m. Eastern time.
Right, so second.
Point of order. This intended to conclude this meeting. We previously adopted a policy manual measure that specifically address adjourning from an in-person meeting to online.
We did not.
The one you're thinking of, well, there's a policy manual that was
As long
essentially.
as to continue a regular meeting,
No.
so, you know, we're setting up a separate meeting as a special meeting, and it can't be a continuation.
And that's why it's not a special meeting, it's a recess.
I am.
No, it
going
needs to be a
now.
special meeting. It can't be the same one. It's not at the same location. It violates Robert's rules that way. Postpone, I'm sorry, go ahead.
Okay, so this is the point of order I'm going to raise. A recess is a short intermission or break within a meeting that does not end the meeting or restore its continuity as a single gathering, after which proceedings are immediately resumed to the point where they were interrupted. During the recess, members may leave the hall in which the meeting is being held, but they are expected to remain nearby. A recess frequently has a purpose connected with the meeting itself. We are not remaining nearby. It is not a recess.
So it is an adjournment. You would have to postpone the meeting.
So postpone and adjourn.
Is that Robert's reading?
Yes.
So the proper procedure here is to postpone.
Because they're not going to do it in Arkansas or some other state, it's just online?
Yeah, we can do it online. We just have to postpone it, and then if it goes to the next special meeting, you can add that to the agenda. So we postpone it to the next meeting, and then adjourn this meeting.
It's number
Okay,
5.
so then to be in order, I'm speaking with the parliamentarian now, so it would be, I would adjourn to continue to a continued meeting, which would be this meeting, so that we can pick up where we left off for June 1st, 7 p.m. So Sunday, June 1st, 7 p.m. Eastern time. And it would be via teleconference, which we are allowed to do per our bylaws. And that's what we would do. And we've done this in the past. It should not be hard. Guys, how can we not get such easy stuff done? We need to do this like now.
I'm raising an additional point of order. My point of order is that our policy manual defines online meetings as special meetings. Our bylaws have regular meetings. Regular meetings and special meetings are not the same thing. You cannot adjourn a regular meeting to a special meeting. In order to do this, we would need to amend the policy manual. And the policy manual specifically says that online meetings are special meetings. You cannot make one thing another. You can't make a zebra into an elephant. It just cannot happen.
Then how about I revise my motion just to adjourn?
We was approved a specific policy amendment that says this is initiated from a regular meeting versus.
Show me that policy manual.
Either way, we have the power to adopt special rules of order here. So it should be, and again,
Without notice, it would require a majority of the entire LNC.
What if we just
That's fine,
motion
so-
to adjourn and left it undone?
So if we have a majority, so it's part of the motion. So if we have a majority, so if everyone agrees, then we're good.
A majority of the entire LNC would require 10 votes.
Okay, so.
That would be a proper motion.
Why do we have to worry about this? Can we just agendize all of it?
Yeah.
Pretty much the same thing.
What the concern is, let's get the elephant out. What the concern is that there are certain members who missed this meeting that will be considered to have auto-resigned once we adjourn this meeting. I don't mind giving them names if people would want them.
Yeah.
Okay, no, you're here.
I said let's meet.
That would be Mr. Bracco, that would be Mr. Nana, and that would be Ms. Hayes. And then one strike against them would be Mr. Benson and Mr. Watkins and Mr. Lamb.
But alternates are included?
Yes, they are.
So this just makes it easy. We don't have to do the whole thing. Ms. Hayes would get reappointed. It wouldn't be a big deal, but let's not punish Mr. Nana and Mr. Bracco.
I'll just revise my motion to a motion to adjourn.
Hold on, I think yours is motion second, so.
Yeah.
So basically, my opinion, somebody can try to overturn my ruling, but I'm gonna rule that it's in order because I do believe it's basically a continuation of the current meeting. And so if more than 10 people agree, then it's blessed by the board essentially. So if there's no further discussion, we can vote on it and see what happens.
I don't understand where we're at parliamentarily, so are you saying that as long as 10 people vote for it, it's okay? Because I would agree with you as long as more than 10 people.
Exactly.
I would object this, object to it, to what, I could appeal the ruling if you want, but I'm just saying there's like a coherency issue here because this is not going to be the same meeting continued online.
It would be.
No, it's going to be a different meeting 30 days later that we have time to
It's not 30
potentially,
days later. It's June 1st.
It would
regardless.
be a continuation of this session to the June 1st. Basically, we would reconvene online.
But it would be in a different location with no continuity, so it's an abuse of the recess to use it this way.
Well, you're telling that opinion.
Look, I worked really hard.
I know.
You know, I came a really long way,
But
and
it's not being recognized right now, so please. So we're gonna go ahead, unless there's any other points of order, anything else.
Sorry, one more time.
I'm still unclear as to your ruling. Is your ruling no matter what the vote is, it is, or is your ruling that as long as 10 members plus it? Okay, because I agree with
Yeah,
that.
10 members. Yeah, so let's go, if it gets 10 votes, then great, if not, go back to the drawing board. All right, so all in favor?
I have not appealed your ruling.
I understand. I know, but all in favor of the motion that, to basically go on to June 1st meeting? We got 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. So it is in order, and we did it by the book, and
Yep,
see you
that's by
guys
the
on
book.
June 1st.
Cool.
All right.
Much love, everybody. We got through it. We made it. We're
Council
live.
Motion number 7, up and running. June 1st. All right, well, everybody should have it now.